Well, welcome everybody. I appreciate everybody coming out here today to the final night of our Community Justice Academy. It is great to see everyone. And I just want everybody to know that this is one of the most rewarding weeks that we do in the entire prosecutor's office, because it's our opportunity to just have meaningful interactions with people in the community and discuss some topics that impact the criminal justice system. An important reminder about these topics: we get these topics from the conversations that we have with people in the community. And so as we close out here today, if there is something that you are interested in or something that you would like to see us discuss next year, please let us know, because that really is what drives our conversations and the topics that we have, not only at the Community Justice Academy, but other events that we do through the prosecutor's office. We want to be responsive to the needs of the community and make sure that we're sharing as much information as possible about what's going on, and hopefully be able to help people maybe learn a little bit more about a particular topic, but also it's our chance to kind of get a better feel for where the community stands on different issues, which is incredibly important to us. This is the final night, so it's T-shirt time in the city. And I see a great cross-section of T-shirts on people here today, which is always wonderful to see. But so for everyone who's been here for all 3 weeks, you will receive a T-shirt. I did get an email from someone who literally emailed me from the hospital. She said, I broke my leg, but I want you to know I'm watching on YouTube. So number one, hello. Number two, Michael will make sure you get your T-shirt. And so I guess if you have a doctor's note and you missed one of the days, we'll still get you a T-shirt. So thank you for everybody for your willingness to continue to participate with us. We look forward to passing out these T-shirts, and also at the end, we'd love to do a picture with everybody. This event is truly for people in the community, so thank you for being a part of this conversation. One of the biggest topics that we have in our community is the issue of mental health and mental illness, and how that intersects with the criminal justice system and what that looks like. I can tell you there's probably not a day that goes by where I don't have a conversation with somebody about how mental illness impacts the community as a whole, as well as the criminal justice system. What can the prosecutor's office do in regards to those issues? What can we as people in the community do to address the challenge and the problems that we have as it relates to mental health and mental illness that unfortunately is very prevalent in our community? And one of the things that we've tried to do is, we as the prosecutor's office can't always be looking just how can we punish people, in particular people with legitimate mental health issues, but it's how can we help change behavior. And one of the best ways you can help change behavior is try to give people the tools to be successful and fashion plans that address the underlying mental health issues. One of the things that I think is incredibly important, one of the things I hope everyone takes away from this, is mental health is not a one-size-fits-all approach. You have to have individually tailored programming that addresses someone's specific needs, which is time-consuming and costly, but is absolutely worth it at the end of the day. And so a lot of times we have the ability to have interactions and maybe an intervention point in someone's life through the criminal justice system, and how can we maximize that opportunity to make sure that we help that person and get the most out of the experience for that individual, and hopefully get them on the right track with resources. And so today we have two wonderful guests who work and who have dedicated their professional careers to helping people with mental health and mental illness here in Marion County. One of them happens to work for our office, and one of them happens to work for the Marion County Public Defender Agency. Both do a good job of serving the needs of individuals who are experiencing these challenges in our community. So the way tonight is going to work, we're going to turn the floor over to them for about the next 45 minutes, and around 7 o'clock we'll begin the presentation of handing out the shirts and the certificates, and hopefully take a picture and answer any questions that you guys might have. But thank you for being here and participating in a very important discussion. And I'd like to introduce our panelists. Mr. Ross, he is a public defender in Marion County's Mental Health Alternative Court. He also serves on the board of directors for the Mental Health America of Indianapolis. Steve's passion for mental health related issues has been lifelong. His professional focus on it began when, as a new attorney, he saw firsthand how pervasive mental illness and addiction are in our justice system, particularly in our jails. Steve believes every person who lives with mental illness or addiction is entitled to dignity, respect, and autonomy. Our community needs to improve how we serve these individuals, and he's excited to be a part of that. Please give it up for my good friend, Steve Ross. And someone I have the pleasure of working with each and every single day, who's been an outstanding advocate and someone who routinely educates me about the challenges related to mental health and mental illness in our county here, is Natalie Mongarella. Natalie is the Deputy Prosecuting Attorney in the county's Mental Health Alternative Court and a board member of the Mental Health America in Indianapolis. Her passion for mental health was initially inspired by working with veterans and seeing the intersections of addiction, mental health, and the criminal justice system. She is motivated by what a difference support and treatment can make for individuals in our community. She believes that every step we take to support just one person is a step towards a healthier, better community. Please give it up for my good friend, Natalie Mongarella.
Like Ryan said, my name is Natalie Mongarella. I have been a deputy prosecutor for about 3 years, and I've been working in the mental health alternative courts for 2 of them. A little bit mentioned before, I started in law school with Veterans Court of Southern Indiana, so that's what really inspired me to get involved with problem-solving courts once I became an attorney.
And I'm Steve. I have been with the Public Defender Agency since I graduated law school in 2019, and I've been in the mental health court since 2021. And I'm excited to be here tonight, and I appreciate you folks being here as well.
Does this actually work, or did I just manage to make it work?
You sit that on the barrel.
I'll do it that way. Okay. So tonight, what we're going to talk to you about, we're going to start with some statistics, some numbers we'd like for you to keep in your heads while we go through the presentation. And we're going to talk about what might happen, what would typically happen, especially before mental health courts became a thing for cases that come up in the criminal justice system, and then some of our alternative programs that we offer in Marion County. And then we'll give you a little bit of an update on Senate Bill 1, if you've heard of that, and some of the benefits of 988, which is taking over the crisis and suicide lifeline number that used to be in place. So in Marion County, this past year, 58,000 adults had alcohol and or a drug use disorder, and 163,000 of those adults had some type of a mental illness. We know that COVID had an impact on all of our mental health, certainly, but with COVID affecting people's access to their appointments, getting treatment, their medication, other issues with housing, food insecurity, homelessness, it certainly exacerbated a lot of those mental health issues for people in our community. 39,000 have a serious mental illness. You're going to hear that term frequently throughout the presentation. When you think of a serious mental illness, there's not a specific list that we can just point to and say, yeah, that's one of them, but think about things that are impacting people's daily lives, ability to take care of themselves, focus on other productive things that might be going on in their life. Any mental illness that is having those profound effects on a person can qualify as a serious mental illness. So nearly 26,000 adults needed but did not receive any treatment for their serious mental illness, and 55,000 needed treatment for a substance use disorder in Marion County. Again, a lot of these people that we end up interacting with are dual diagnosis, is what we call them. They have both a serious mental illness and a substance use disorder. A huge issue that we see in our community and all across America is the self-medication with illicit drugs or alcohol when people have a serious mental illness, and we know those things can exacerbate symptoms that people are having, or even sometimes cause an onset of symptoms that they otherwise did not have before. So dual diagnosis is certainly a huge factor that plays into what we do every day. Drug intoxication was the leading cause of death for the 3rd year in a row in Marion County. The next causes of death were blunt force trauma at 511 and cardiovascular death at 499. So there is a lot of accidental drug overdose that's occurring. I'm not sure what other panels everybody has been to. I'm sure you guys have certainly heard about the dangers of fentanyl that is posing in our community. And going back to that dual diagnosis issue that we're facing, that is certainly something that we are concerned with. We're going to give you a hypothetical to also think about with those numbers as we go through our presentation.
All right, so we find that sometimes it's easier to digest the higher level concepts that we're talking about when you have a specific set of facts in mind, so that's what this hypothetical is about. We're going to refer to it throughout, so keep this in mind as we go, please. So, this is the hypothetical of John Doe. IMPD officers are dispatched to the downtown transit center on a report that a person has threatened to physically harm a bus driver. Upon arrival, they see a bus rolling to a stop. Officers see a person later identified as John Doe trying to force his way out of the closed bus doors, screaming for the driver to let him out. Officers hear John loudly threaten to throw the bus driver off the bus, but he does not make any physical efforts towards doing so. The doors open and other officers temporarily detain John. I pulled this from slides for our police training. So officers temporarily detain John for safety while they investigate. There is no one with John, but he seems to be speaking with someone beside him who isn't really there. Officers speak with Bob, the bus driver. He tells them that John Doe is riding the bus, behaving normally until John asks to get off at a location that isn't a bus stop. When Bob refused to stop, John became very angry and repeatedly threatened to throw Bob off the bus. John did not actually try to carry out that threat. When the bus didn't stop, John attempted to force open the bus door while it was still moving. So officers then speak with John Doe himself. He tells them that some of the other passengers are FBI agents who have been following him around for months. None of the passengers identified themselves to officers as federal agents. This isn't the first time officers have encountered John Doe. He's been arrested numerous times, and he's also been asked to leave various locations downtown without being formally arrested. So on this occasion, officers arrest John, take him to the county jail, where he's charged with intimidation as a level 6 felony and held on a $500 cash bond that he cannot afford. A lawyer from the Marion County Public Defender Agency is appointed to represent him. During a jail visit, John tells his lawyer that he hears voices that others cannot. He's gone to Eskenazi for treatment in the past, but hasn't seen his doctor in about a year, or taken his medication in about a year, and that was before the bus station incident. Since he's been in jail, he is taking medication, and he feels better than he did before his arrest. John signs forms giving his lawyer permission to get his medical records from Eskenazi and the jail. He also reluctantly shares that he smoked spice shortly before the incident on the bus. His lawyer later confirms that John is diagnosed with schizophrenia with multiple co-occurring substance use disorders, and Eskenazi confirms that they closed his chart about a year ago when he stopped showing up for appointments. So, again, please keep these facts in mind as we go through. We're going to refer back to them after each section. So this next part is about the traditional justice process. And what I mean by that is the old-fashioned process where a criminal case either goes to trial, where a jury or a judge decides what happened, or the person pleads guilty either by agreement or open to the judge, meaning the judge decides what to do without an agreement. The traditional justice system is not designed for people with mental illness. It's not designed to help them. The formal procedural tools that we have that specifically apply to mental illness is what this first part of the presentation is going to be about. And they're very limited as far as how much they can help the person or help the lawyer help the person. So we're going to talk about 4 traditional concepts. The first one is the insanity defense. The next one is competency to stand trial. Then we'll talk about the guilty but mentally ill verdict. And then we'll talk about mental illness, but first I need to drink water.
How many people think competency and the insanity defense are the same thing? Anybody?
Good, they're not. Before I go into these concepts, I do want to touch on one kind of high-level concept, which is, one second. So as a society, we've decided that there's a pretty big difference between causing harm when somebody knows that they're doing something wrong and causing harm when someone doesn't know they're doing something wrong or doesn't even know what they're doing at all. So in criminal law is about holding people accountable when they cause harm while they know they're doing something wrong. So, criminal law, we require both a wrongful act. We also require that while a person is doing that wrongful act, they also have a guilty mind at the same time. If you don't have both of those things, no criminal offense has been committed. So, that is another way of saying basically what our law says, which is a person is not responsible for having engaged in prohibited conduct if, as a result of mental disease or defect, he was unable to appreciate the wrongfulness of the conduct at the time of the offense. So, one option that a defendant has and a defense lawyer has when we're looking at a case is to put on an affirmative defense. And an affirmative defense is a type of defense where we're saying, if what the state says happened, if I did what they say I did, I'm still not legally responsible, I'm still not guilty because of a legal reason. Another affirmative defense is self-defense. Yes, I hurt somebody, but I was hurting somebody because I was defending myself. That's a different kind of affirmative defense. This affirmative defense says, if the alleged conduct happened, I, the defendant, am not responsible because of my mental state at the time of the offense. So a person, again, I skipped my first bullet point, a person who meets this definition is referred to as insane at the time of the offense. That is not a nice thing to call someone in any other context, but in the law, it's still the accepted term for this specific situation. For this affirmative defense, the defendant has the burden of proof, which is different from most of the other parts of the criminal trial. The state has the burden of proof. But in this instance, the defendant has to prove by a preponderance of the evidence, meaning more likely than not, that he was unable to appreciate the wrongfulness of his conduct at the time because of a mental disease or defect. This is a very, very rarely used defense for a bunch of reasons we're about to go into. It's used in less than 1% of cases, and only in a fraction of those is the person actually found not guilty by reason of insanity. So, the verdict of not guilty by reason of insanity should only be reached by the jury if the prosecutor has proven their case, if the prosecutor has proven the person did the conduct that they're accused of doing. So if the state has proven that the person did the alleged conduct, then the jury can reach, if the jury also believes the defendant that he didn't understand the wrongfulness of his actions at the time, then the jury can decide that the person is not guilty by reason of insanity. If the state has not proven that the alleged conduct happened, the verdict should just be not guilty without the insanity part. So if a person is found not guilty by reason of insanity, which again is a very rare situation, that verdict results in a civil commitment hearing where the judge then decides, okay, the criminal case is over, you've been found not guilty, but you're still mentally ill and maybe you've harmed someone, depending on the case. So the judge will decide then whether it's appropriate to continue to hold that person in a state hospital or place them under essentially an order to be treated. I'm going to skip to another concept and come back to competency because it makes more sense in this order. So the jury has another option when the defense brings up the insanity defense. The jury can also decide, well, we think the state has proven that the conduct happened and we believe the defendant was mentally ill, but we also think that he was able to appreciate the wrongfulness of his actions. So they can reach this kind of middle ground called guilty but mentally ill. This is not a very old type of verdict, relatively speaking. It was invented by state legislatures in the 1970s and 80s in response to several high-profile cases where some folks hurt somebody or tried to hurt somebody and then were found not guilty by reason of insanity. The most famous of those would be John Hinckley's acquittal by reason of insanity after the attempted assassination of Ronald Reagan. So this verdict does not entitle the defendant to any specific credit, reduction of sentence, really not much of anything except the following. The judge has to order an evaluation if one has not already been done. The judge has to at least consider mental illness as a potential mitigating factor in sentencing, meaning is it a possible reason to give the person a lower sentence than they would otherwise get. And also, if the person is sentenced to the Department of Corrections, the Department of Corrections is required by this statute to perform further evaluation and provide treatment. As you might get by kind of my tone on this, this is a controversial type of verdict. organizations like the American Bar Association's Criminal Justice Committee say it shouldn't exist because it dissuades jurors from finding people not guilty by reason of insanity when maybe they should. That's just my opinion and the opinion of a lot of other folks that are smarter than me. So there's some controversy about this type of verdict. It can also be made as a plea, but for all the reasons I just talked about, there's not a very strong reason for a defendant to make this plea in the justice system. So I'm going to go back to competency now. So we're shifting gears. This competency is not about the mental state of the person at the time of the offense. Competency is about their mental state from before trial and during trial. So to legally stand trial in the United States, a person must have sufficient present ability to consult with his lawyer with a reasonable degree of rational understanding and a rational as well as factual understanding of the proceedings against him. He has to be able to communicate with his lawyer, relay facts, talk about what happened in private to his lawyer so his lawyer can understand how best to defend him. And he or she or they have got to understand what's going on in the courtroom, what the players are, what a prosecutor does, what a defense attorney does, what a judge does. If they can't do either of those things, they are not competent to stand trial. So a person who meets that standard in the last slide is referred to as competent, and a person who does not is called incompetent. Putting an incompetent person on trial is a violation of the U.S. Constitution. A person also has a constitutional right to be competent for probation and community corrections proceedings. The statutes don't talk about that, but our courts have said that that is the case. So if at any time before the very end of the trial, the judge thinks that there are reasonable grounds for believing the defendant is incompetent, the court has to stop the proceedings and order a competency evaluation. 2 doctors are appointed, usually psychologists or psychiatrists. Sometimes it can be a physician that is not a psychiatrist. And they evaluate the person and submit a report to the court about their mental state. A 3rd doctor is appointed if the first 2 don't agree with each other. And then the judge reads the reports. There's an evidentiary hearing if the parties think that's necessary in the case, and then the judge makes the final decision. If the judge decides that the person is incompetent, they are committed to the Division of Mental Health and Addiction for restoration. Sometimes that means going to the state hospital. Sometimes that means going to a private hospital. It's contracted with TMHA. But if the person's in the state hospital, it costs the state $2,033 per day, per person, to restore someone to competency. So it's very expensive. The person's usually returned to jail after they're restored. Hopefully they get the same medication that they got while they're at the state hospital. Hopefully it happens on time, but that's not always the case in practice. And of course, the jail's doing their best to do that, but it just doesn't always happen. Because the person's being returned in custody, the state hospital is not able to set them up with an outpatient treatment provider like Eskenazi or Adult and Child or Aspire or Community, so that they can continue the progress they made while they were at the state hospital to begin with. So essentially, they are sent back to the jail with a letter from the superintendent of their facility saying, this person's ready to be tried. But they're not set up to continue the success that they started out. And then the final concept for this traditional part is mental illness as a mitigating factor. So Indiana law says that a trial judge should doesn't have to consider mental illness as a mitigating factor. They do have to at least think about it if the person is found guilty but mentally ill, like we talked about before. But they use these 4 factors. I'm not going to read these to you, but they're essentially these 4 factors are what the judge needs to consider when deciding whether to give mitigating weight, meaning lower their sentence because of the mental illness. And that is the traditional process. It's necessary for some folks. Some crimes are simply too serious to be resolved with the alternative solutions that Natalie's going to talk about in a second, but at least in my view, that's the very, very minority of cases. In the majority of cases, there is a better way, as far as I'm concerned. I kind of accidentally answered my discussion question before. But how well do we think the traditional process is going to help John Doe? You can just shout it out.
Not well.
No, it's not going to help him. At best, he's going to be the same as he was to start with. He could be worse. He could be re-traumatized in jail. but he's not going to be better. It's not going to help him. It's not going to put him in a better position. And the community's not going to be in any better position. The community's not going to be any safer if John Doe's not helped. So that is the first part, and Natalie's going to talk to you about the better options.
Alrighty, so like we said before, we are the two parties, the prosecutor and the public defender, in our mental health alternative courts that we've got here in Marion County. Our first one is called PAIR. I didn't name it. I'm not a huge fan of the name. It's the Psychiatric Assertive Identification Referral Program. So we call it PAIR. PAIR is for our pending cases, so things that have not already gone to trial or any kind of a plea, they have not been resolved, and they come to us, and we'll go a little more in detail with what's required of people in PAIR. But they come to our program, and that is one of our newer ways of resolving pending cases. We also have a behavioral health court, which is for post-conviction cases. So these people have already been sentenced, usually or all the time, to community corrections, home detention, or probation, and they either have to be at risk of violating or already in violation of those programs because they have one of those serious mental illnesses. The other programs that we've got in Marion County, we do have a drug treatment court. In practicality, all of these problem-solving courts are very similar to PAIR and behavioral health court in terms of what's required of participants at the very base level. Drug treatment court is exactly what it sounds like, people whose number one factor that led them into the criminal justice system is some sort of a substance use disorder. The Indianapolis Veterans Court, most of those people are having either an issue with a substance use disorder or a mental health issue, but they also happen to be a veteran. So that one's structured a little more differently. They kind of take on a militaristic tone with everybody and building camaraderie and battle buddies and that kind of thing. So that one works very, very well for our veterans. Re-entry court is for people who are coming out of the Department of Corrections to re-enter into society and how to help support them do those things. Our felony diversion program is similar. It's helping those who have been convicted with a felony help reduce recidivism. You know, how do you find housing? How do you get into treatment? How do you get your basic needs covered so you don't end up picking up another case? And then in the past couple of years, our office has started the Quality of Life program to address crimes of homelessness in Marion County. Those are this person's hanging out at Thornton's day in, day out. They keep getting trespassed, and now they have 7 criminal matters pending in the courts because they don't have anywhere else to go, and so they hang out at Thornton's, and it annoys the Thornton's guy. So we have programs like Quality of Life to help those people find resources for housing, food insecurity, treatment if they so need that. But that's also for pending cases that we have in Marion County. So within our mental health alternative courts, like I said, we have PAIR and behavioral health court. They're both for people with serious mental illness, and they're both what we call problem-solving courts, much like the other ones. These problem-solving courts are non-adversarial, and I don't always like the term adversarial even for our regular courts because we do typically get along with our public defender and defense attorney counterparts. We do work together every single day. But those regular courts are adversarial. You're arguing different sides of the law and your case law and the facts of your case. Our non-adversarial problem-solving courts, we have a meeting with the judge and the case managers every day before we go to court, and we discuss how everybody's doing, all the participants, what's going on with their treatment, what's going on with their life, what updates do we have to discuss, and we all, as a team, figure out what sanctions and incentives would be better addressed to either curb or encourage whatever behavior someone's showing. So that's how problem-solving courts work. in a nutshell. Both of our programs, they are voluntary. So we have what's called our opt-in period. We've, as an office, decided that this person might be eligible for PAIR, but now they have a time period to come to court, see how everything works, and then they decide whether or not they're going to do it. Sometimes it can be pretty discouraging. We think that this is going to be a great program for somebody, and we put a lot of work in to get them up to speed in that 6 weeks, and at the end of it they go, yeah, it's not really for me. Or they go out and maybe they're just not ready to get treatment, they're not ready to re-engage, so they might pick up another case. Or they just decided that they'd rather resolve their case in one of the traditional ways. So, but they are voluntary programs, as are drug treatment court and veterans court. Our mental health courts are with Judge Amy Jones. If you've seen her, she's very involved with mental health in Indianapolis and Marion County, so she's on a lot of boards and panels to address these issues. Our court coordinator's name is Lindsay Connor. She works through probation. I am the prosecutor, Steve's the public defender, and then we've got Alexis Schroeder, Ryan Lawson, who are both through probation. They work with each program respectively. And then Dawn is our community corrections case manager. And then Kelsey Conley is our recovery coach, which is specific to behavioral health court, although I think all problem-solving courts would benefit from more recovery coaches, and especially people with lived experience who want to help others. So PAIR actually, it is a mental health deferral program, but it's a deferral of sentencing, technically. They do plead guilty when they decide at the end of that opt-in period they are ready to do the program, so they do take a plea agreement to enter into the program officially. If they are successful in the program, they've done all that they need to do, at the end of it they do get their charges dismissed. So thinking about competency, when someone's not competent, they're not able to enter into any kind of a plea agreement, they're not able to go to trial. If someone comes to us incompetent, we do have to go through that restoration process to reach a resolution or to even get them into PAIR or behavioral health court at all. So everyone in PAIR is diagnosed with a serious mental illness. We don't take any crimes or cases that have a deadly weapon. Sometimes we can look at things where it's charged with a deadly weapon, but it was really a spoon, or something that's not by itself a deadly weapon. But we're not taking any cases with guns and knives as of now. For their criminal history, no more than 2 forcible felonies. Think of just any violent kind of batteries is usually what comes up. We do get alleged victim approval before we allow somebody to enter into our program, make sure that that's what all the parties involved want as a resolution. And they have to be willing to engage in that mental health treatment. During that opt-in period with us, they're coming to court every single week to see how the program works. And then once they sign on and sign that agreement, they come every 2 to 6 weeks as they progress through the program and depending on their compliance with what we're asking of them. They have to be compliant with their mental health treatment. That's number 1. Anything that their provider at Eskenazi or community or wherever they decide to go, if they're requiring them to go through a program through the hospital, they're required to do that. We also have them drug test twice a week, and they have to meet with that case manager pretty regularly, and Steve very, very regularly. And if they're able to do that for a year, adhere to that mental health treatment, and they are compliant with their drug screens, anything else that the court might put in place, they get that case dismissed. I mentioned before a lot of our dual diagnosis issues, so I would say the number 1 thing that comes up as a reporting requirement that we use in PAIR at behavioral health court would be substance use treatment, either detox, sober living, and transitional housing is our number 1 requirement for a lot of people, and our need for a lot of people in the community. If someone is not able to be successful with PAIR, and they've already signed up. We have a termination hearing for them. At that point, we come up with a sentence that is either similar to a regular plea agreement, or a lot of times they have stuck it out with us for a period of time. We do know a lot about them. We know a lot about their story. We know what they've been through and what they're continuing to go through. So Steve and I will work out a different kind of agreement that you wouldn't necessarily see from a regular courtroom. But they do stay with us in Court 34 to be resolved instead of being sent back to the regular adversarial court. Behavioral health court, like I said before, they either have to be at risk of violation or in violation status. They've already been sentenced in an adversarial court prior. This court, because we have that recovery coach, that's another set of eyes on our team, we do take more moderate, high risk, high need individuals into this program than we can in PAIR. Similar to PAIR, they have to have a serious mental illness. All of our people in behavioral health court have a felony conviction, and their participation is 1 to 3 years, and sometimes that includes like the entire sentence that they've been given for probation or community corrections, and they just serve that with us. We decide who is going to be admitted into behavioral health court as a team, and they are screened using the IRAS tool, which is a probation tool also used in other problem-solving courts. It looks at different factors in people's lives that might lead them to be more likely to pick up a criminal case or to fall into any kind of substance use disorder. Things like family history, family relationships that are going on, previous drug use, what age that drug use started, and other things like that. And they get a score at the end of that, and that's how we determine that high risk, high need person. As well as with PAIR, they're coming to court the same amount of weeks, and then they progress. We also have phases in behavioral health court, so they come to court a little less frequently as they get more stable and more compliant with the program. The goal of behavioral health court is stability and the ability to let our participants back out into the community in a better way that they were before, hopefully with housing and at least a couple of years worth of medication and drug treatment under their belts. The problem-solving courts, again, use that sanction and incentive model. All of them do. It's the idea that in a regular courtroom, and I don't know who's ever seen a regular court proceeding or a hearing, but they're usually pretty quick. The lawyers have already decided and talked to each other, either we're setting a trial date, we're going to fight this out, we're going to take a plea agreement, oh, I didn't look at the thing you sent, so we're going to talk about it later, and here's your next court date, and the person moves on. And there's really not a lot of interaction for the defendant or for victims or anybody to be heard in any given hearing that we see. So the biggest piece of that with the problem-solving courts is the praise and finger shaking sometimes that our judge gives to people. She's able to sit down and spend time with each defendant every court hearing and say, hey, I heard your dog passed away, I'm really sorry about that. And just to hear that somebody cares about you, somebody from a position of power especially, is really impactful for our participants. And then also when the judge says, hey, you went out and you had a beer this weekend and you really shouldn't have done that, that carries a lot more weight than somebody who doesn't know them. They're just being passed along through the system as we go. This is how applications get started. It usually starts with the public defender noticing something about their client that would lend us to believe that they have a serious mental illness. But what this all boils down to is that it's a voluntary, both of them are voluntary programs, and it's up to that person to decide if they're ready to sign on to this commitment. And like I mentioned before, we've got that drug treatment court in the Veterans Court as well, and reentry court. They all, especially drug treatment court and Veterans Court, have a very similar phase structure, drug testing structure, and that sanction incentive program. Other things that we see in the adversarial hearings and courts are the diversion agreements. That's up to the prosecutor in any given court. They admit the probable cause for the charge, but not necessarily guilt. And then they can go through community service is a big one. We also have classes that we would require people to take for different sorts of crimes. If it's something related to a theft or a store, there's anti-theft classes. There's a whole book of things that we can require somebody to do in the theory of behavior modification versus punishment. That felony diversion program is for those felony convictions and trying to reduce recidivism, and then that quality of life program is for our low-level crimes of homelessness. So what do we think is the best option for John Doe? BHC? Anybody else?
Depends if he's on drugs or are we assuming he's not?
He did admit to smoking spice. So that's a synthetic marijuana that is, there's all kinds of stuff that's in it. Due to the level of the crime, he would qualify for behavioral health court or PAIR. I would usually lend more towards PAIR to avoid him getting that conviction, especially since nobody was hurt in this situation. And to go to your thought about the drugs, and we run into this a lot. Like I said, we have this dual diagnosis program. The prosecutor who runs our drug treatment court, his name's Kevin Shepard. Sometimes he'll get an application and then they'll come back and say, this person's got schizophrenia and that's their main, that's the top level issue. We got to get that under control, and if we get the mental health piece under control, we can get the drug piece under control. And so it's more the driving factor in those cases. Is their primary issue the mental health piece, or is it the drug piece? Yes?
And have you guys ever thought about if John Doe had these other situations, if they would have got some help, it wouldn't have went to this last one?
Yes.
I mean, with the felony.
Right. And in theory, that's why we want to catch them and bring them into the criminal justice system, but catch those issues as they arise, maybe with the quality of life program. Somebody's just kind of running around town, nowhere to go, they're experiencing all of these other things, that we can get them those resources then, and then dismiss those cases because they've been successful getting into the programming that they need. That's going to keep them from going 2 years without being medicated or hanging out on the street and getting involved in a different kind of drug than they may not have been involved in before. So that's the theory behind things like the quality of life program.
So are these offered to these people when they first come into the justice system, or is it offered after they've been tested?
In a perfect world, in the world that Steve and I like to pretend that we live in, yes, they would be offered those things off the bat. And we do our best, especially within recent years. We've gone to a ton of trainings. If you want to look things up after, Miami-Dade County in Florida, Arizona, and Tennessee. There's a city in Tennessee, I think it might be Memphis, that are doing that really, really well. And so it's just a matter of bringing those ideas back, and then also making sure that there's the resources to back those things up. And we'll talk about it later, but the momentum behind Senate Bill 1 and the ARPA money that came down from the federal government to address mental health issues, I do think the momentum's in the right place, but we're not quite there yet. So as of now, Steve and I do our best to talk to our respective offices and say, here are the options that you have when you interact with defendants, and things to be paying attention to in court and picking up on, so that we can hopefully get more people into these programs and divert it away from the thing, just the bad crimes that needed to be dealt with. And then we have the people that we can give resources to and get treatment for that are no longer going to be a risk to the community. Yes?
Governor Newsom in California has launched a care court. Much of this sounds extremely similar. Was there a cart before the horse, or are lots of organizations around the country doing this?
I think they're happening simultaneously. There's certainly a larger focus on mental health, homelessness, and drug addiction in the past, I would say 5 years, but 10 years than there was before. So somebody's got one good idea, and maybe in some places it is a little cart before the horse, but it's all happening simultaneously, so we're doing a better job to unsilo ourselves is a big term that people use, and to share resources and say, hey, this is working really well in a city of this size versus a smaller community can point their resources over here, and that's going to work better for them than it would for Marion County.
I have a question. How
Yes.
difficult is it for you to find transitional housing for your clients?
Very.
Very, very
That's what I
difficult.
thought.
Yeah.
So hard, worst part of our job.
Yeah.
Because nobody wants that in their neighborhood.
Exactly, and I mentioned what I said, that what we need is really those transitional housing pieces, even detox places, especially with what we do, because we're not that drug treatment court, we also have to find places that will take a dual diagnosis client, and not all of them do. And then sober living versus transitional housing, again, not all of them will take a dual diagnosis person, or a lot of times it'll say, you know, if your drug of choice is meth, the detox period is completely different than with other drugs, and so it's not, people don't meet medical need after being sat in the jail if their drug of choice is one drug over the other. I don't know if you want to fill anything in on that.
Yeah, the question for the video was, how hard is it to find transitional housing? And the answer is extremely difficult. I would say between myself, the rest of the team, I can't take most of the credit for it. Most of it is done by our recovery coaches, our case managers, probation officers, and social workers. It's very difficult to find housing for individuals who meet the criteria for our programs.
So, and I apologize if I missed this answer through the presentation, but so a lot of mental illnesses, for example, are unfortunately lifelong diagnoses. So let's assume that somebody goes through the program, they complete everything perfectly, attend their classes in court, and everything is great. 6 months down the road, they get into a toxic relationship, they just stop taking their meds, whatever the case is. Are they eligible to go back through the program again, or is it a one-for-all shot and you're done?
For the person who did everything right the first time, it's a lot easier for them to come back. You know, our Gold Star student, and they have this slip up later on, it's just the logical leap of they're going to come back into the program is a little bit easier because of that. But yes, they are eligible.
Yeah. I get that question from lawyers a lot. I know my guy already went through PAIR 2 years ago. Can you go again? And my answer is always going to be, Judge Jones is going to ask me what's going to be different this time.
Yeah.
So if when that particular question comes to me a lot, and I tell the lawyer, let's sit down and figure out if we can tell a story about how it's going to be different this time. Maybe something's changed in their life. Maybe maybe we can look into their medical records and show that they made a good faith effort towards treatment and something happened recently. But it can be difficult to convince Judge Jones and Natalie sometimes to give somebody another try who wasn't willing to help themselves the first time. And I wasn't able to convince them that something else is going to be different, if that makes sense.
I will also say, for the most part, it's usually not the Gold Star student who, especially that quickly, would be running into a relapse or stopping taking their medication. Just given the nature of our program, I think we are the most at risk of having people re-enter the criminal justice system, just for the fact that a huge thing with mental health treatment is you take your medication, wow, I feel so much better. I don't need it anymore. And then they stop, and then the symptoms just progress much more quickly than a lot of us realize. And you can end up in a situation where the cops have been called, where you're back where you started, which I think would be a good segue into
Yep.
SB1. So we had some information here about involuntary treatment. But like I said, I think that was a good segue, and for the interest of time, I don't know how much time we've got.
5 minutes.
5 minutes? Okay. So has everybody heard of SB1? I know there was a lot of talk about it in the news and everything. Okay. So Senate Bill 1, they have started 988, which was also a federal mandate for the states to start. And it replaces the really long suicide crisis number that used to exist, and in hopes more people will use that over calling 911. We do our best to train our officers in crisis intervention, but they didn't go into being police officers to be mental health providers. So they are not always the ideal group to show up to a scene where somebody is just having a mental health crisis. What SB1 also did is establish these certified community behavioral health clinics, and the hope is that we're going to have these crisis response services in all of our Indiana counties. So the purpose of 988 is someone to contact, someone to respond, and somewhere to go. I will say we have been at a conference. There are other Indiana counties that have implemented this. They've even gotten to the point where officers don't have to respond with the therapist at all. They just have a team that is able to service these calls and react and go to the scene themselves. And these crisis stabilization units are going to be, and we skipped over the involuntary commitment part, but taking someone to the ER and putting it into the doctor's hands to decide whether they're going to be held in the ER for 72 hours is a different idea than what these crisis stabilization units are. Sometimes someone's having a really bad night and they have found themselves in a crisis. They're scaring their family that's around. It's not necessarily going to rise to the threshold of a 72-hour hold, but they can't stay in the environment that they're in right now because there's a risk of something dangerous happening. And so these crisis stabilization units are supposed to be somewhere for everybody to go should they need essentially just a time away.
Is this 988 24 hours?
Yes. And like I said, other counties have been able to open these stabilization units and have their mobile crisis teams fully staffed. So I do have hope that Marion County is going to get to that point. Obviously, we are the biggest one, so it's harder to get all of our ducks in a row here and as quickly as some of the smaller counties. So that's 988. It is access to the trained crisis counselors, mental health first aid people, and you can also call 988 even if you're not with somebody. Like, let's say you're getting a text from a loved one who seems like they're experiencing a crisis, or they're having suicidal thoughts or making plans. You can call 988 for that person as well. And there have been 6 million calls since July of 2022. And you can call for, like I said, suicidal thoughts, substance use, mental health crisis, or any other kind of emotional distress instead of calling 911. Like I said, you can call for somebody else. I don't feel like I need to read everything to you, but you can also block your number if you needed to. And then if there is an immediate risk of life, they will call, or they can call a 911 dispatcher who will look up where that incident is occurring. So once you call, you would speak to a crisis specialist, and they will determine from there, divert the resources either to 911 or that mobile crisis unit. And if they needed it, then they will have somewhere to go. I think as of now, in Marion County, people will end up at Eskenazi. That's usually where the police are taking people anyway. And that is where you would go in this instance. And then obviously, if there's a fire, you should call 911. Don't call 988 for a fire. But for police and medical services, still call 911, and then 988 again is for that emotional crisis response. Could 988 have helped John Doe, do we think? Possibly. Or maybe before. Maybe he was having a really bad night before he got on the bus, and 988 would have helped if somebody, or if he had been able to use that service. And tell everybody you know about 988. Not a lot of people know yet that this is an option. It is up and running, and you can use it if you need it. I don't know, do we give people slides? Okay, so you will have access to these links if you want to go look at them yourself.
I have a question.
Yes.
For a person calling 988, what's going to be the benefit over the people that have called 911 for a person with a mental health situation and those people ended up dead? So
the person who was in crisis?
Yes.
So typically, and what we've seen statistically, that result has happened when 911 is called over 988.
Okay.
The idea is that 988, you're getting a trained mental health professional, and then that someone to respond will also include a mental health professional who's trained much more in depth than a crisis intervention trained officer in de-escalation to avoid that. There's also, at least with the smaller counties who have been able to get to the point of not having police respond, there's no weapons involved. Especially for somebody in crisis, people showing up with a badge and a gun, and it is much more triggering than somebody in plain clothes. And IMPD does have those officers, but they're spread much far and few between throughout IMPD than what we hope is going to be the number for 988 for Marion County. Anything else?
You mentioned state hospitals. I thought since LaRue Carter and Central State closed down, there wasn't state mental health hospital.
There is a state hospital. It's in Logansport. They've also been using, through Senate Bill 1 especially, these private hospitals that they're able to use. I think there's about 4 throughout the state, spread north to south, that they're able to use in Vanderburgh County, I believe, also has one. So they have contracts.
Valley Vista, the Neurodiagnostic Institute, and 2 other ones.
Wellstone, I know, is one in southern Indiana as well.
Okay.
So that's how they're able to spread the influx outside of Logansport, is through those private contracts.
What's the name of the one in Logansport?
I think it's just
Logansport State Hospital.
Oh, okay.
Thank you.
Thanks for coming, everybody.
Well, thank you guys. Please give it up for our panelists. And get us on this so very important discussion. Before we get to the certificates and the t-shirts, just want to let everybody know this truly is a team effort for everybody at the prosecutor's office. And so Mr. Kelsey is going to help us hand out some of these certificates, but just want to acknowledge not only Mr. Kelsey, we got Jack back there. Jack, say hello to everybody. There you go. Even a few puffs for Jack. He's not used to that. Good stuff. There you go. Marissa right there. Say hello to Marissa. Michael Leffler, Salida, my man Jake right there, of course Natalie, and then one of the newest additions to our teams, Johnny Winstead, who's in charge of our strategic partnerships. So if there's anybody out there who's looking to hook up with the prosecutor's office or say, hey, I had this idea, or I had this question, or you work with a community-based organization, please reach out, make that contact with Johnny. We want to make sure that we have good relationships with people in the community and we continue this flow of information. So take advantage of that. I want to thank our friends at Channel 16 for being willing to come out here and film this and make sure we get on YouTube. So thank you very much. Very grateful for that. And thank you to all of you who have participated both online and in person. We really appreciate all of this. But we need your feedback. In your folders, you will have an evaluation form or a survey. Tell us what you liked, tell us what you didn't like, and then also we really want to hear about what topics you would like to see covered next year or at different community events that the prosecutor's office participates over the course of the year. If there are topics that you think require more immediate attention, you'd like to see us more directly address those, please take advantage of that opportunity. We really pay attention to the feedback that you provide. So take a look at that and let us know.